Hello friends, welcome back to our channel. Earlier the channel used to be in the name of LGU's classes, but for the convenience of our subscribers and other students, I have changed this name to Project 21A. Basically, this name deals with Article 21A, right to education, which is a fundamental right. So, through this channel, I would like to impart education to each and everyone who is unable to take subscriptions of hi-fi online courses, and also for the ones who are self-preparing for this subject. So, we are going to start today's session with the complete course on Indian Evidence Act. Firstly, I would like to tell that in this lecture, we are going to deal with one by one each section and every word of the section as well. And I'm not going to provide you any typical complete notes, because notes, if I'm going to provide you a notes, then you all will stick to that particular notes only. So I'm going to give you important pointers in such a way that all those who are pursuing LLB and for their semester exams, as well as for the judiciary aspirants also, they can add on in their notes. And those points are really very important, because I have taken those points from the DJS or other competitive exams questions. Okay, so without wasting time, let's start. Firstly, we are going to discuss about the brief introduction of this Indian Evidence Act, such as the historical background, and thereafter we are dealing with every section. So stick to our channel, and please do subscribe if you like, and for more content, press the bell icon. Okay, so let's start. Introduction and history of Indian Evidence Act. See, evidence. What is evidence? Firstly, let's understand what is the meaning of evidence in a layman language, or we can say in a basic terminology. We can say that evidence is defined as something that leads to a conclusion. It becomes a ground for belief to back up or refute any argument in the sense, whatever point we are raising in the court, whatever argument we are putting before the judge, in order to support that argument or in order to refute the argument made by the other party, we used evidence. Okay, so basically we can say it is a something that leads to a conclusion, that a final point in question. So in order to get a relief, it is most adjective procedural law. It is a most adjective in means, I have underlined this word, adjective procedural law. Adjective procedural law means purely it is a procedural law. Many laws are there where some of the sections are substantive in nature, whereas this evidence act, it is purely procedural law. Only one section we will be discussing in detail, that is I think 115 section. It basically is a single section which talks about substantive law. Apart from it, it completely procedure in nature. Now let's see the landmark case, Zahira Habibullah Sheikh versus State of Gujarat, 2004 Supreme Court. In this, the Honorable Supreme Court has discussed the basic ideal. What is the basic ideal of evidence? See, Indian evidence has one basic ideal, that is a fair trial. Now, what is fair trial? Fair trial is a basic aspect of right to life. Hence, if there is a bad evidence, there is not a fair trial. And if there is not a fair trial, it vitiates Article 21, that is right to life. Now next, let's see First Evidence Act when it came. First Evidence Act came up in 1835, which is the amalgamation of Hindu, Muslim and common law of Britishers. Earlier, we all know, earlier there used to be a common law which applied on Britishers, because Britishers were not aware of the personal laws such as Hindu or Muslim law, which were earlier prevailing in our country. So they have amalgamated. Earlier they were separated laws. For Muslims they were Muslim law, for Hindus they were Hindu law, and when Britishers came, they have made their personal common law, which they call common law. But for the convenient in criminal law, they need an evidence act. So First Evidence Act was the amalgamation, that is combining Hindu, Muslim and common law of Britishers into one act, which is known as First Evidence Act 1835. There were there were many technicalities, or there were many problems in the first act. So thereafter a second evidence act in 1855 came. This was divided into two laws. Earlier it were three amalgamation of three laws, but now it is two law, that is common law which applies to British, and the local laws for trial courts. See, the second evidence act was divided into two. One was the one for the common law for the Britishers only, and other for the rest of Indians, including Muslim, Hindu, everyone is combined in it. Thereafter, in 1872, our Indian Evidence Act came into existence, which was drafted by Sir James Fitz Stephen, who is also called as father of Indian Evidence Act. Basically, write down these points in your notes, or whatever notes you are self preparing, add on it, because it will be of great help for the exams point of view also, whereas in academics also. Now, originally, Indian Evidence Act contained 167 sections, 11 chapters, and one schedule. But in 1938, one schedule was repealed. Now, Indian Evidence Act only contained 167 sections and 11 chapters. Now, there is a question which comes most of the times. Indian Evidence Act is a Lex Fori. What is the meaning of Lex Fori? In Lex Fori को आसान भाषा में समझने के लिए ऐसा बोल सकते हैं, लॉ ऑफ द लैंड. लॉ ऑफ द लैंड कैसे? लेट्स सी. लेक्स फॉरी मीन्स द लॉ ऑफ प्लेस. द प्लेस, सी द पॉइंट टू बी नोटेड, लॉ ऑफ प्लेस वेयर द क्वेश्चन अराइजेज, यानी कि जहाँ मैटर इन डिस्प्यूट है, जिस जगह पे मैटर इन कॉन्ट्रोवर्सी जिस कोर्ट में डिसाइड हो रहा है, उसी कोर्ट का, उसी प्लेस का लॉ लगेगा. इसीलिए इंडियन एविडेंस एक्ट को लॉ लेक्स फॉरी बोलते हैं. देखिए एग्जाम्पल. If the question arises whether person is competent witness or particular fact is admissible, competent witness, particular fact, admissibility, ये सब हम आगे डिस्कस करेंगे. बस अभी एग्जाम्पल समझते हैं. इफ़ द क्वेश्चन अराइजेज विद द पर्सन इज competent विटनेस और पर्टिकुलर फैक्ट इज एडमिसिबल, इट शैल बी डिसाइडेड अकॉर्डिंग टू द लॉ ऑफ द कंट्री वेयर फोरम दैट इज कोर्ट एग्जिस्ट. यानी कि जिस जगह का कोर्ट होगा, जहाँ पे मैटर इन कॉन्ट्रोवर्सी चल रहा होगा, डिसाइड हो रहा होगा, वहीं पे हम लोग ये लगाएंगे. ठीक है, तो अभी के लिए बस इतना ही है. इस पॉइंट्स को आप लिख लीजिएगा, ये मेजर पॉइंट्स बनाइए. इसके अंदर पैराग्राफ में आप अपने खुद के नोट से, जो कि आप अदर सोर्सेज जो भी होता है, ऑनलाइन सोर्सेज या बुक से रेफ़र करके आप पैराग्राफ वाइज इसमें ऐड ऑन कर सकते हैं. बट फॉर द टाइम बीइंग ये जितना लिखवाया है इसको लिख लीजिए. आई कुड गिव यू माई पर्सनल नोट्स, बट द प्रॉब्लम इज़ माई हैंड राइटिंग इज़ नॉट दैट मच गुड. So I have made this slides for your convenient, or further if you need anything or there's any doubt regarding it, do comment in the comment box and I will surely reply. Thank you.